I'm Ben Meiselas from the MeidasTouch network. Rudy Giuliani, it turns out, would use the name Helen and use a Gmail account called rhelen0528 at Gmail when communicating with people like Mark Meadows and others in Trump's inner circle. We are learning about this from a new filing by the lawyers for Ruby Freeman and Shay Moss in connection with their defamation case against Giuliani. Of course, Rudy Giuliani so flagrantly and despicably defamed Freeman and Moss, basically referring to them as drug dealers and saying that they stole thumb drives that changed the votes and made the votes turn for President Biden instead of Donald Trump. All of this completely and utterly false. Also, Rudy Giuliani produced in support of that defamatory claim a clearly doctored video and tried to misrepresent the contents of what that video was. And so Ruby Freeman and Shay Moss brought a defamation case in Washington, D.C., federal court. It's before Judge Beryl Howell. Of course, you've heard that name. She used to be the presiding judge over the various grand juries in the D.C. federal court. And one of the things that was happening in this case is that Rudy Giuliani was just utilizing the MAGA playbook, right? Delay, and then he would not produce records. He would claim that the records don't exist. And Rudy Giuliani forced Ruby Freeman and Shay Moss's lawyers to file multiple motions throughout 2023. Finally, when the judge essentially compelled Giuliani to produce these records, Rudy Giuliani claimed that he was too broke to produce records. He claimed that he owed the electronic discovery vendor, TrustPoint, over $300,000, and he claimed that he was unable to pay it. And as a result, for being $300,000 plus in arrears, he said he could not participate in discovery. So what happens next? Judge Beryl Howell forces Rudy Giuliani to submit a declaration under penal perjury about Rudy Giuliani's financial condition to demonstrate proof that he is literally bankrupt and had to be a detailed financial statement under penalty of perjury. And then the day before that was due, Rudy Giuliani submitted a new declaration claiming that he found the $300,000 plus, and he is able to participate in discovery now. And one of the reasons Rudy Giuliani was doing this is that the deadlines for what's called fact discovery, before you get into expert discovery, where the parties exchange emails and text messages and other documents in their custody and control, as well as subpoena third-party documents, that deadline was set to expire. I think it was sometime in late May or early June. So Rudy Giuliani was trying to run out the clock, and Ruby Freeman and Shay Moss's lawyers were very, very smart. At all times, they continued to call him out. And so the judge, federal judge Beryl Howell, was intimately aware of this. And so what was Rudy Giuliani trying to hide? Well, I think like all MAGA Republicans, everything, including the fact that he would use this email address, rhelen0528 at Gmail, when he would communicate with people like Mark Meadows. According to this new report, and it's in the filing, Rudy Giuliani used an email address with the name Helen in some of his communications about his efforts to oppose former President Trump's 2020 election loss, as late as a late 2020 email sent to Mark Meadows about a plan that Trump allies hoped could impose martial law after the election was CC'd to Helen and Lucy, so they were clearly using code names there. A message included in that case indicates Giuliani has rhelen0528 and was CC'd on discussions about an executive order that some Trump allies believe could be used as a pretext to seize voting machines and even impose martial law following Trump's election loss. Giuliani, who's the former mayor of New York and personal attorney to Trump, had discussed his use of the email address rhelen0528@gmail in the court appearances as part of this case, as part of this defamation case brought by Ruby Freeman and Shay Moss. And according to the case documents that were just made public this past week, the address is one of 7 that is at the center of the fight over documents in that case. Quote, "That was my main Gmail account since I had Gmail," Giuliani said in a deposition on March 1, 2023. "And somehow others were created for specific purposes, but that would cover 95% of my email I had, and probably every important one." Giuliani's mother, who passed away in 2002, was named Helen. That is why the email address is that. But he would be using this alias to communicate as part of his plot to overthrow the election, in addition to being highly relevant in connection with Ruby Freeman and Shay Moss's case, as that's the main repository of where Giuliani would send and receive communications. Certainly also going to be helpful for Special Counsel Jack Smith to prove intent, to prove the willfulness, because why else would you try to hide and cover it up if you thought that everything you were doing was above board? And certainly this revelation will be very, very, very important for the Fulton County District Attorney, Fani Willis. Here's just a brief background on the discovery dispute. I think it's interesting, so let me read from the court documents. It says, "Plaintiffs filed a motion to compel defendant Giuliani only after he spent nearly a year avoiding the most basic discovery obligations. During that time, defendant Giuliani refused to provide any clarity as to his preservation, collection, search, and production efforts, offering only vague, inconsistent, incomplete, and half-hearted claims about what he had or had not done in discovery and what email accounts, messaging applications, social media, or phone numbers he used during the relevant time period. He did not provide that information even after the court ordered him to do so to avoid a motion to compel, and instead indicated his to-date efforts were sufficient based on demonstrably incomplete searches, using that term generously, of email extensions of whatever pre-April 2021 emails were located in TrustPoint and post-April 2021 content located in unspecified devices and social media. Only in opposition to plaintiff's motion to compel did defendant Giuliani claim for the first time that he was now financially unable to engage in any further discovery. Defendant Giuliani maintained his claims of inability to pay throughout a 3-hour hearing on the motion to compel that the court held on May 19, 2023, subsequent to which the court reserved ruling on plaintiff's motion to compel and ordered defendant Giuliani to first, 1, file a declaration detailing his preservation, collection, and search efforts, the location and the data of potentially responsive documents, the specific data located in TrustPoint, and his search of those locations and data, and 2, produce all financial information requested in plaintiff's request for production of documents number 41 and 42, and documentation to support his estimated costs to search TrustPoint. On the evening of Friday, May 26, counsel for defendant Giuliani notified plaintiff of the, quote, significant development that defendant Giuliani has been able to procure third-party funding to cure the arrearage to search the TrustPoint docs. Defendant subsequently filed the reconsideration motion as to the portion of the May 19th order compelling the production of financial documents and submitted the declaration to purportedly respond to the court's May 19th order, in which he professes a desire to search for responsive records, but still apparently only those located in TrustPoint. In other words, after requesting the court and plaintiffs expend considerable time and resources to address his claims of financial distress, defendant Giuliani has withdrawn that excuse and return the parties to virtually the same position that necessitated plaintiffs to ask the court for permission to move to compel in the first place, and defendant now seeks to undo the court's May 19th order requiring him to produce his financial records. The reconsideration motion provides no basis in law why the court should consider its order or to reconsider its order or to accept the same objection that it previously found insufficient. As for the defendant Giuliani's declaration, it does not sufficiently address the court's May 19th order and further affirms the court's May 31 order requiring defendant Giuliani to engage a professional vendor to preserve, collect, and search for all materials responsive to plaintiff's request for production. Whatever, quote, efforts defendant Giuliani describes in his declaration provide little clarity into what data and sources, if any, he has preserved, collected, and searched to date, and what defendant Giuliani does not say in his declaration, coupled with the representations his counsel and he made at the motion to compel hearing, demonstrate the insufficiency of any such efforts. It is apparent that defendant Giuliani has not attempted to preserve or collect data from all potential sources of responsive documents. He has instead relied on whatever data the government purportedly seized, and whichever of the data is stored in Trust Point, the contents of which defendant Giuliani does not appear to know and has not explained to the court. And defendant Giuliani's personal search efforts are demonstrably incomplete because he did not locate and produce responsive documents that were produced to plaintiffs by third parties. The court has rightly compelled defendant Giuliani to engage a professional vendor to attempt to cure his own lack of discovery efforts to date. And in that motion, it goes on to talk about, for example, all the other email accounts that Giuliani would use, how he would go and hide his emails using the R. Helen address, all of the bad faith efforts that Giuliani has engaged in. And one important thing of note, on June 5th, the court issued a minute order that granted the parties' motion for an order altering the existing scheduling order, and it pushed all of the dates back as a result of Giuliani's conduct. So, it's one of the things when you litigate these cases with Trump and MAGA, they play games and games and games. They abuse the process. They abuse the fact that courts like when parties are collegial and voluntarily share the appropriate documents. They don't play by those rules. So you have to do just what Ruby Freeman and Shane Moss's lawyers did here, and a great find and discovery, of course, that Giuliani uses rhelen0528@gmail.com to send messages relating to the insurrection. He would refer to himself as Helen in those messages. As I said, Jack Smith probably very intrigued by this, as is Fawny Willis, the Fulton County District Attorney. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 1.5 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch, and wherever you get audio podcasts, subscribe to the MeidasTouch podcast. All right, hit subscribe on our YouTube channel and have a great day.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.